Professor Roosevelt, how would your ideal justice vote on the constitutionality of a federal law requiring all colleges, universities, and graduate schools receiving federal funds in any form to implement a race-neutral numerical identification system for their applicants, and prohibiting admission boards or staff from accessing race-identifying data such as names or photographs?
Well, again, the question would be first, where does Congress get the power to do this? And since we're talking about federal funds, that provides a pretty easy source of federal power. As I said before, when you pay the piper, you call the tune. So I think that the difficult question here is going to be, is there a constitutional right that this offends? Now, in the affirmative action context, there was an argument made. The court didn't take it all that seriously, but there was an argument made, and you'll see it actually in some of the older cases, that schools have a constitutionally protected First Amendment interest in shaping their class. And they have this interest, the idea is, because they're engaged in an expressive activity, they're trying to educate, they're trying to teach a particular lesson, and constructing a class within which that education takes place most effectively is part of their educational mission and part of their expressive activity. So the question would be, does this unconstitutionally burden that right? And I think the answer is going to be no. I mean, I find this a difficult question. I do have some sympathy for the idea that certainly as a matter of policy, we should give educators a fair amount of autonomy in deciding how best to carry out their mission. But of course I agree, policy is not a constitutional consideration. We've got to ask, is there a constitutional limit here that the federal government has overstepped? And I think the answer is no. I think if Congress passes this law, my ideal justice would uphold it.
Thank you. Mr. Levey, how would your ideal justice vote on such a law?
I would largely agree, or my ideal justice would largely agree with Professor Roosevelt. I think federal funding certainly gives you the jurisdictional hook for Congress getting involved here. Equal protection does as well. Certainly when this has been proposed in recent times, it's been to combat reverse discrimination, knowing that that schools engage in reverse discrimination. Public schools are certainly reachable through the Equal Protection Clause, and you're trying to prevent discrimination. Again, we can argue about, as a matter of policy, whether it's okay to discriminate against white folks or not in order to have more racial diversity, but clearly it falls within the subject matter of the 14th Amendment. I also agree with Professor Roosevelt that, again, if you were going to make a case, it would be the academic freedom argument, but he's right. Schools haven't taken it the courts haven't taken it very seriously, and I think that's because you can't take it very seriously. If you were going to take it seriously, ask yourself, if you flip things, does a school have the academic freedom to say, we think we'd have a better learning environment if we just had a wider student body? So we're going to apply more rigorous admission criteria to minority students. Nobody thinks that a school has academic freedom to do that. And I think that's often a good test to turn it around, flip the races, because that allows us to distinguish between sort of our politically correct instincts and the law. And I think here, if you do that, it's clear that the law would not say there's academic freedom to discriminate based on race.
So you would agree with Justice Roberts' observation that the only way to end discrimination is to end discrimination?
Well, I think that's a policy matter. No. I mean, as a policy matter, agree with him, but that's not what I'm saying here. I simply said two things, that one, this would fall under the it clearly falls under Congress's powers under the Equal Protection Clause if they're doing it to prevent discrimination against white people or even Asian people who are said to be hurt even worse by affirmative action. And I said there's not a separate First Amendment right for schools to discriminate. But I don't think that what Robert said is, I think he meant it as a wise statement, not as a description of constitutional law.
Thank you.